Thank you very much. As Tommaso had said, my name is Erwin Voloder. I'm the head of policy at the European Blockchain Association, and I was very fortunate to join Blockchain for Europe, European Crypto Initiative, and ADBA, and the Digital Currency Governance Group in this open letter around the Data Act, where we garnered over, I believe it was 70 plus signatures from various industry participants, some of them sitting here with us as well. Basically, to highlight the industry's concerns around some of the language around the Data Act and how this could potentially impact the public permissionless space. For those of you who are not familiar with the Data Act, it is a piece of legislation that was tabled recently and that has since gone through trialogues that seeks to legislate data sharing agreements in the EU. As Tommaso had mentioned, data is a non-rival good in European terms, so this is also supposed to let's say, bring the bargaining power back on the side of consumers with respect to how they engage with SMEs, also in terms of data sharing agreements and transfer of data. And I'm joined today by Aditya and by Jordan and by Kurt, who I will also let them introduce themselves. We'll do a brief tour de tab before we jump into the topic.
Go ahead.
Okay. So nice to meet you, everybody. My name is Jordan Maris. I'm the Senior Policy Advisor to Karen Melchior in the European Parliament. I'm among the people who worked on the Data Act. And I wanted to start with a little bit of a story, which just, I think, illustrates a lot of the problems that we face. So a couple of months ago now, the Commission came to us with this lovely proposal, and it was a proposal that was going to solve a serious societal problem, something really nasty. And we all sat around the table and had the first reading of this proposal. And the first thing that I noticed is that it was not technically feasible. There was a problem with it, which meant that we would either have to abandon the architecture of the internet as we know it, or abandon the proposal. So as you do in this situation, I politely suggested that perhaps there are some technical issues that need to be addressed. Now, this resulted in like a 20-minute back and forth between the Commission's representative and I. And at the end of these 20 minutes, he slammed his hand down on the table and said to us, "I assure you, this proposal is legally sound." To which, I mean, I only discovered afterwards he was a lawyer and not a specialist. To our disappointment, it may have been legally sound, but not technically. And I think that's like the core of the problem that we have here. It's that there's often this misunderstanding between the legal and the technical. And both with regards to feasibility, but also with regards to the language that the lawyers use to try to describe the technology. And whenever there's uncertainty, the lawyers pick these very specific terms, which leave the industry often kind of hanging, wondering if a certain piece of legislation applies to them or not. So yeah, I think that's the heart of the issue, and I can't wait to get into the depths of it. Thank you.
Excellent. Thanks. Aditya.
Is it working? Yeah. So my name is Aditya, and I am here on behalf of Fujitsu. And we were contributed to the open letter because there were some of the things that we thought it would be better, because it's all about technology neutrality that we were advocating. And so there were three things that I think we will talk about all those. So it's about the scope of Article 30, the nomenclature. We proposed that we substitute smart contract by digital contract. And maybe when we'll go into the nitty-gritty details, you will see why we proposed that. And also the scope, as I mentioned, the Article 30 and one article regulating the whole smart contract is something which is, I think, is not correct. And also bringing that scope to private permission blockchain. And it's related also to Article 2.16, where the definition, let's say, of the smart contract is mentioned. So these three things, basically, I'm here to talk about more when we get into those details, so that it brings more clarity. And we are here just to make the policy and technology work together. So yeah, that's
Wonderful.
all from my side.
Thank you. Kurt.
Hello, everybody. Good to be here. So I'm Kurt Opsahl. I am the Associate General Counsel for Cybersecurity and Civil Liberties Policy at the Filecoin Foundation. And, you know, the challenge of having technology and law interact is, one of the great challenges of our age. When, as you're saying, like when lawmakers try to enact policy around technology, it's critical to understand how that technology works and what some of the challenges and limitations are with that. And when they come together, sometimes they don't mesh up happen. I think this is a little bit of what has happened with the Data Act, where the intent is very important. It's very like trying to protect people's privacy, giving them some control over their data. But then it comes up against a technology and a terminology that is different from a lot of the lawmakers. I think the intent, as you're saying, was to try to make this work in an IoT area where people are going to be using these smart contracts in sort of a specific situation. And then how this will affect the rest of it, well, hopefully it will not be as bad as we fear, but in the raw language of the bill, it is quite troubling. And so I'm looking forward to getting more into this conversation.
Excellent. Thank you very much, gentlemen, for your introductions and your opening statements. I think we could start with maybe more of a broader question. What do you think, like from a market perspective, which industries realistically, and I mean this can be tangentially touching smart contracts as well, would be most impacted by the Data Act as it's currently written?
I mean, I think the big problem is it affects everyone. I mean, the Data Act covers everything from smart toasters to aircraft to cloud storage. There's not one industry that's not had a problem with that. I mean, we received multiple hundred requests for meetings, and we weren't able to take them all. There were so many people who wanted to meet. I think also this is part of the source of the issue that we have. It's that there were just so many stakeholders, so many interested parties, that some things didn't get the attention that they needed and deserved.
Sure.
So I think the big problem is it impacts everyone. I mean, maybe cloud and compute providers a bit more, but I'd say it's pretty much universal.
Okay.
I think I also would like to say that to give a picture, at least to understand what we are talking about, connected devices, Industry 4.0, where we are living in today, cyber physical systems, where I think more than 30 billion devices are connected today. And in a couple of years, 75 billion. And if you can imagine, if you zoom out, like the amount of data generated, exchanged, or streamed is huge. So we are not just talking about one industry or one horizontal or one vertical. It's impacting everything: finance, healthcare, supply chain. So that's the importance of this Data Act, because it's going to act as a framework where we are building the digital future of tomorrow. So it's impacting, it's horizontal, it's everywhere. So it's impacting every industry.
Kurt?
Yeah, I mean, I very much agree. I mean, you come to a time in which basically every device is connected to the internet and is generating data at all times. And, as you're just mentioning that there are 30 billion devices. I mean, that means like there are many multiple devices as there are people in the world. And we're coming to a point where everything you do will create a data event that is going to be recorded and potentially transmitted somewhere. So trying to get a handle on that and trying to make sure that people have sort of the privacy or the autonomy to give themselves privacy, to have some control over their data, is important. And it's going to affect basically everyone, and every business will have some piece in it. And if they're not now, they will be soon. But this also means that any legislation in this area is going to have tremendous effects.
And I think this is really the scale of the problem, is that you're dealing with a piece of legislation that is horizontally covering any sector where you're going to have data exchange in some fashion between the devices and the way that data is supposed to be transferred in agreements, also with regards to how those devices are operating. And I think from an Industry 4.0 perspective, as you had pointed out, that's possibly the biggest elephant in the room, is that we're talking about something that is essentially going to determine how the zeitgeist of technological development is actually supposed to be embalmed together. And this isn't, at least from the perspective of the industry, necessarily clear. And this brings me to my second question, and you touched on it already, Aditya, with regards to Article 30. The proposition in Article 30 that smart contracts need to have what's called safe and robust termination. Okay, so I mean, colloquially, you could refer that to something fashions of a kill switch, right? And from an industry perspective, we argued that, as you had pointed out, this scope should be relegated for private permission blockchains, because the way that data will be transmitted in private permission blockchains and the way that such access control features operate within those settings is going to be vastly different than it would be on public permissionless blockchains. And so if you could just elaborate, what do you think could be the consequences of transposing that wholesale requirement to public permissionless blockchains.
Do you want to start or?
Yeah, sure. So first of all, I would like to really quote what smart contract, the definition is. It's really important, and I note it down. So in Article 2.16, smart contract means a computer program used for automated execution of an agreement or part thereof, using a sequence of electronic data record and ensuring their integrity and the accuracy of their chronological ordering. All this doesn't mean that we have to use a digital ledger technology or a blockchain. There are ways, and I can go into the rabbit hole, how you can do it without a blockchain. So the overarching principles regulating a smart contract, or the Article 30 talking about smart contract, it's not about all blockchain, all smart contracts, all DeFi, and all this permissionless blockchain. So we have to understand that. That's why first point that we made about substituting smart contract with digital contract would make sense. Then coming to that kill switch that we are talking about, the termination or pausing, in technological context, we can do that. It exists. If you don't know, it was depreciated just, I think, in Feb 2023. There is something called as, to name it exactly, let me, there is something called a self-destruct, which existed in Solidity. It was just deprecated in 2023. But there are ways, there are smart contracts that you can pause or you can unpause based on certain conditions. So now coming back to Article 30 and what it is all about, robustness and access control, it talks about giving that kind of equivalence so that it is equal to the legal contract in that sense. And then it talks about the scope, where we are talking about public. But if you look at access control, if you look at robustness, all these things we already do in the private context. How we have this enterprise blockchain where we work in, where Fujitsu works in, it's by default, not even by design. It's by default having those mechanisms. So what we are saying also in the open letter is to bring that scope back to private closed permission. But if you have to do it, if you have to implement this termination, as I said, it's possible, you can. But the big question is, in the public, in the decentralized world, who will trigger that switch? What is the governance behind? And you have to understand, and we cannot forget, it's a decentralized world. Once it's done, you cannot back off. So these are the things that you have to make sure that what is the mechanism behind, what is the governance behind, but of course it can be done. So that's what I would like to end on.
Okay. Well, I mean, I think that we will have a lot in common on this matter. I mean, I think that one of the key things is the approach of the Commission in this was likely like at the end of the work on the file thinking, okay, we need to future-proof it, we need to think about smart contracts. The problem is the Data Act is already 3 laws in a trench coat, essentially. You have access to data by government, you have interoperability of cloud, and you have Internet of Things, devices, and data access data. So throwing this in on top, I think, was a mistake, and it was not sufficiently clear. Now, I'm not going to say much from a technical perspective, as I'm not a technical expert on the blockchain, but I think one of the advantages of smart contracts on the blockchain is their like deterministic, predictable nature. You know, they're immutable, which basically means we know what's going to happen when they run. And introducing kill switches kind of doesn't entirely nullify, but risks nullifying those benefits. So like what I think lawmakers keep failing to understand is that you can't have your cake and eat it. Trying to retrofit the benefits from what would be a traditional contract into smart contracts sometimes defeats the purpose of having a smart contract entirely. So you kind of got to think about your use case, and that's all I have on this question.
Great. Great.
Yeah, I think one of the challenges is that a sort of smart contract is a bit of a misnomer, that it is just a program that has been called a contract, but it doesn't share a lot of the qualities of a contract. In fact, it's kind of trying to improve on the contract. That rather than trust in the other party to abide by the terms and enforce that with a court if they fail to do so, you have the program, you can look at the code of the program, you, as I say, are deterministic, you know what it's going to do. And this takes out some of the trust that is otherwise necessary when you're doing a paper or traditional contract. And this is one of the great values of blockchain technologies is to have this to be, programmable money, to have it so that if something happens, X, Y, and Z, a condition is met, then some value will be transferred, for example, a common use case. And permissionless systems are a great part of that value. And they're kind of the opposite of access controls, where you have to have permission, you have to have access control credentials in order to use something. So by enforcing robust access controls and a kill switch, it is taking away some of the values of having immutable contracts that automatically execute and that anyone can use. Right? Those are some of the key propositions of what the value out of these programs, these smart programs that we're now calling smart contracts, by trying to sort of retrofit some contractual actions to it. Now, you could have a user of this, a company that is using a smart contract to transfer data, and they could stop using it pretty easily. And then if the program, it doesn't store the data, it just passes it through to somewhere else. And so you could have a mechanism that would stop it or kill it in that sense. But if you have a system where the program is killed for every user, then you're destroying great value. And so these are some of the concerns, at least. And I understand the intent of the bill was to have it deal with a more sort of specific set of circumstances, and limiting it to that intent would be hopefully able to be done through some at least, if not changes in the wording, some guidelines, some interpretations of language. But like as it stands, it poses a risk to one of the great values of blockchain.
I think trying to just synthesize all of your points there, in my discussions with lawmakers, it's almost been that there's a conflating argument between, what may or may not be a smart legal contract or a Ricardian contract, and what may be a smart contract and what may be a digital contract and a data sharing agreement that employs a digital contract. And I think that arguably the skepticism regarding immutability, it's something that, has been shared openly in the past. But if you want to make that argument, I mean, it's the immutability is really what makes a smart contract commercially viable in the first place. That is the value proposition, the USP for the smart contract. So I think that, we see this tension play out within the Data Act, but we also see, a closer reading. You could make the argument that, terms like standardization and interoperability are used almost interchangeably throughout the text when they don't actually have the same equivalence in neither at law nor in a technical sense. And what are your views on that? Specifically how, regulators might approach, conceptualizing these two topics versus how, industry might approach it.
So this is another difficult one. It's another case of the Commission's lawyers being extremely careful with their wording. Before I dive into this, I really want to say that, having spoken to all the people I've spoken to on this file, people who are working on it and who've worked on it, I really don't think it's supposed to apply to blockchains at all. I mean, maybe to private ones, but definitely not to public ones. I think that the wording is so unclear that it's created that problem. But there is a bigger question here, and it's does the blockchain community want for the Data Act to apply to them? Do they want to be part of this sort of data sharing system that we're setting up by regulating? And at the end of the day, the answer to that question defines everything that comes next. I mean, in my view, and from my guess at what the European Commission's lawyers do, I'd see interoperability as being the goal. So interoperability can be achieved in many ways. There are already some blockchain technologies that allow interoperability between different ledgers. Polkadot, I think, is one of them that's quite recent. That's having essentially the community or the industry do it. There's also standardization, which is a route towards interoperability in some cases. But I think it's also important to see the difference between what you guys might see as standardization, so setting out a standardized data structure for something, and what the regulators and the standard setters might see. So for them, it might be more about the features of a smart contract. And there we go back into the issue of, are we going to try and bring features from a normal contract into smart contracts, and what would be the consequence of that? I mean, like, I can imagine a world where there's a Euro contract standard with a set of principles, a set of features that have to be respected. And certain blockchains will make that possible, certain others won't. But as it currently stands, it's really dependent on if we want those technologies to be used for that purpose or not in a wider sense. So yeah.
Yeah, I think it means different things to different people. For policy people, it's different. For technologists, it's different. And I think what I can say from technology side, like to give a very simple example, it's like a language that we all can understand the accent and the dialect, and the standardization is like the grammar, so the rules. So for us, it can go, it can co-evolve together. But from the policy side, I think it's like a linear step. You have to do this first, standardization, and then interoperability. So that's the only take. It's the rules of engagement, and that's the how you talk, how you interact, how you share data with different ecosystem. Okay. Yeah.
Yeah, I think the advantage of having the smart contracts is that there are just I think I would just say before, like a condition is met, an action is done. It's like any other kind of computer program, having that immutable and importing the features of legal contracts into that is taking the misnomer or the colloquial term of smart contracts to refer to these kinds of programs and sort of elevating the word contract very highly in that. Like you could have a circumstance in which there's a legal contract involved with a smart contract. People can manifest assent, have agreements, and use a smart contract as part of that. But to standardize it and say that every time you use this program, that is a legal contract, is sort of taking the name of it more than the functionality of it. As it's described in, as we were just reading the definition of smart contract, it is very clear that it's talking about a program, so a computer program, and yet it's still trying to add on to this or bring into it the contractual world. There are many programs out there that might be involved. You could have a contract that involves a notification by email. That is, so they will be using the email protocol to send things, and that's part of the contract terms. But that is not that the email protocol does not become a contract. And so, it's important to not elevate the term contract and take advantage of what things is being able to have things that are programmable, deterministic, and you can trust in them, and you're trusting in them because of the technologies, replacing some of the trust that you might have had by enforcement through other means by knowing it will happen because there's an immutable program that will make it happen.
And I realize that we're running out of time, so I will ask one final wrap-up question. If you could kind of fast forward and let's say the dust has settled on the Data Act and it is now out and it's in force. What do you think, in one sentence, what could we realistically expect once something within these provisions, Article 30, Article 28, is challenged?
I mean, I think we could reasonably expect that absolutely nothing will happen. At this stage, I think the Commission and the Parliament have both made it really, really clear that they don't want this to be in. And then the question comes back to the one I asked. I mean, does the blockchain community want it to be in? Do they want it to be involved in the data act? If so, then, I mean, there are only two things that are certain in life: death and EU regulation. So you're going to face more regulation. You're going to probably face attempts to kind of crowbar in traditional contractual ideas into the chain. Or alternatively, you could keep it pure like it is and have it just purely a yes or no thing. That I think is up more to the blockchain industry, to the blockchain community to decide.
Okay.
Yeah, I think I'll end with saying that it's not the legislative piece that we are discussing. As I said before, it's the framework that can lead to the base where we are building this data-driven future. It's not the policy, it's the future that we are discussing here. So if it can adopt the refinements that we propose, this technical and policy people can meet together, then I think definitely it's for the bigger, better, brighter future.
Great.
Yeah, absolutely. I do hope for a time that you're right, that nothing happens with respect to permissionless systems, and that the enforcement or the interpretation and how we end up seeing this happen shows that intent to have this a narrow focus. And I think the future that we want to have It is one where there's engagement between the blockchain community and the regulators. And I think one of the things is extremely important. A phrase I often use is speak tech to power, and talk to those who will be regulating so they better understand the technology, using the expertise that we have from the technical side to engage with people on the legislative side, so that when they're making policy, they're doing it with the knowledge of how the technology works. And even if we have some disagreements about how the policy should apply, if we're doing it on the bedrock of understanding what the technology does, we can have a much better conversation about how these things will work together and how we can get to that brighter future where we have people have more control over their data, something that a lot of people in the blockchain community want to have, and that we can get it so that we're sort of wrestling back some of the challenges that have come because of this massive amount of data being collected and transmitted all over the world. Putting some order into that'll give people control, but doing it in a way that sort of keeps things intact and allows innovation to continue. Hopefully we can find that conversation and get to a good point.
And I think for me, I would say that, this all just resonates back that we just need to do much, much more education, outreach, communication, and to encourage transparency and to encourage the learning process to continue and to be emergent rather than divisive. And I thank you for your time and for your insight and your expertise. And I hope everyone enjoyed the panel.
Thank you, everyone.